Oh, hey folks, Elder Law Care Attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, today's question by a subscriber is the following, sent in. Hey Patrick, what are some estate planning tips for single parents? Folks, very, very important question for folks who are single and have children. Folks, I'm going to help you today, give you some estate planning tips that will help you protect what you have for the people you love the most. Folks, from my experience, numero uno. Single individuals are a unique situation, and I talk about this a lot at our educational programs in the community, because you do not have the luxury to immediately avoid the first-headed monster, meaning that Bill and Mary, a married couple, conventionally, they hold all their assets jointly with right of survivorship. Bill and Mary on the deed to the home, in real estate, Bill and Mary on the bank accounts, etc., etc., etc. Bill checks out first, gets hit by the bus of life. You have a thing called right of survivorship law to wife Mary. No probate court. They dodged a bullet. They get a second bite of the apple. Not so for you single folks, because you don't have a Bill or a Mary on all your assets with you. So the takeaway, folks, legal technical takeaway, I talk about this in my book and in our programs, is if you own any asset in your name individually, your home, your bank accounts, your investment accounts, your automobile, you get hit by the bus of life, you get hit by lightning, that asset is going to end up in probate court because you don't have a joint owner, okay? And why do folks want to avoid probate? Costs too much, takes too long. You don't want to do that to your loved ones, folks. So please take note, write these notes down. Meet with your elder law attorney, and you want to create a trust, okay? When you create your trust, folks, that is step one of the process right there. It's not a magic red book. You need to engage in step two of the three-step process. Think of your trust like a treasure chest. You have to get your assets transferred to your trust, your real estate, your non-real estate. Get them into the trust, because you know why, folks? Because sadly people die, but trusts do not. So when your assets are owned legally by your trust and you get hit by the bus of life, either a disability or a death, now you avoid probate court. Extremely important for all, but extremely important for single individuals, okay? So that's how you avoid probate court, folks. Also, in your durable power of attorney, in your elder law toolbox, make sure you're giving your agents, your attorney in facts, sufficient gifting authority. If you live in a state here like the Commonwealth of Massachusetts that still has a state death tax, that's a second-headed monster. Because if you're home on your deathbed, home on hospice, it may be prudent and wise to engage in a gifting strategy, but your attorney in fact, your trustee as well in your trust, would need to have the proper legal authority to make large gifts out of your estate before you pass away. And from my experience, most estate plans have limitations and restrictions on the amount of the gift they can make. And also there's a thing in the law called self-dealing. Oftentimes your son, your daughter, your loved one may be your healthcare, your power of attorney agent, your attorney in fact, and they cannot engage in what they call self-dealing, which is making a gift to themselves. That could be detrimental, right? If you want your child to make a gift to themselves so you can reduce the estate tax, you need to have language in your trust and in your power of attorney allowing self-dealing to occur. Otherwise, if they got audited by the taxing authority, that gift may not stand up. So really important, folks. So number one, make sure you create a trust. Number two, not a magic red book. You got to get your treasures in your treasure chest, okay? Because sadly, people die, trusts do not. Also, make sure your durable power of attorney has proper powers in there as well to make gifts, okay? Another thing for single parents, if you are a single parent with minor children, children under 18 years of age, make sure your plan has a proper guardianship protection program in there. So you're legally appointing who your legal guardians will be, because you want to make it easy for a judge in the family court. What does that mean? If you have minor children and you get hit by the bus of life, you better have in your will and in your trust appointed who your appointment would be. Who's the person in your life could legally step into your shoes as your surrogate parent that is going to raise your child the way you want them raised. Don't leave it up to a judge, because the probate courts are very, very busy places. I often say to our clients, your worst pick is oftentimes better than the probate court's best guess, because they don't get it right all the time. Very, very busy place. They'll look at the best interest of the child standard. They may choose If you're a single parent, the biological parent of the child, the other parent, and they may not be in the best interest of your child. I've had cases like that. So make it easy for the judge. Reduce it in writing with your state elder law attorney. Do not cut corners on that, folks, because your child could potentially be at risk. Guardianship protection program or guardianship protection plan in your plan. Extremely important to have that, folks. Folks, thanks for joining us here today at elderlawcare.com. If you found this video helpful, please share it with others. But most certainly, please subscribe. Click the subscribe button on YouTube and click that notification bell, because we'll continue to keep you updated each time we release a new video, because that will help you slay the metaphorical four-headed beast of the state in elder law. Thanks for joining us here today, folks. Patrick Kelleher. See you next time.